Hi, and welcome to All Things Divorce. I'm Lonnie Sheldon, the host of All Things Divorce. Today, we're going to have Annette Burns, and Annette is a family law attorney in Arizona. She's a family law specialist and has practiced in Arizona since 1984. She is the past president of the Association for Family Conciliation Courts from 2016 to 2017, and a former fellow of the American Academy of Matrimonial Lawyers, that's AAML. She received the Community Legal Service Children's Law Center Mentor of the Year Award in 2015, and the State Bar of Arizona Law Family Law Section Lifetime Achievement Award in 2017. She has been named Super Lawyer every year from 2007 to 2023, Arizona's top women super lawyers 2013, 2014, 2019, 2020, 2021, and 2022. And Arizona's top 50 super lawyers in 2008, 2009, 2020, and 2021. She has served on every committee and task force that created, revised, and restyled the Arizona Rules of Family Law Procedure from 2003 to present. Annette is the co-author of BIF, and by the way, I have that book here too.
Oh, great. That's it.
The co-author of BIF for Co-Parent Communication 2020, and of the Arizona Family Law Rules Handbook for Thompson West Publishers. That's updated annually. She maintains a mediation and parenting coordinator practice in Arizona. So I actually asked Annette to give me a short bio, and I knew that she still didn't even touch on so much of the things that she does to help families. So that was about as short as it can get, and still didn't even give her nearly the credit that she should have had. So Annette is amazing. Also, just as I always do, the information provided on this podcast is for entertainment purposes only and should not be considered specific advice for your case. Both Annette and I are only licensed to practice law in Arizona, and listening to this podcast does not create an attorney-client relationship with either me or Annette. That being said, the podcast is available to anyone everywhere, and much of the information can be useful for people in all jurisdictions. So Annette, thank you so much for being here and sharing your expertise. Annette's going to talk about mediations, preparing for mediations, and preparing your clients for mediations.
Well, thanks for having me, Lonnie. I'm happy to be here.
Well, thank you. So I think today we're going to talk about a couple of different kinds of preparing for mediation. One with the attorney preparing, but also then preparing your client. And I think this is going to be really helpful because mediations, one, are so important, but two, they can be less important if you're not prepared.
Oh, yeah.
Okay. So let's talk about the mediation memorandum. You ask parties to provide you with a memorandum before the mediation. Is that true?
Sure. And I would just start this by saying a lot of what I'm saying here today, I'm speaking from the perspective of the mediator, being the mediator, but I also do a lot of cases where I am one of the attorneys representing a party at mediation. So I'm trying to get that perspective both ways, but most of what I'll be answering is coming from the mediator. So what I try to see, or what I like to see when I'm the mediator, is a day or two ahead of the mediation memorandum, a nice written summary, just to give me some background so we don't waste a lot of time with immediate background questions on the day of the mediation. So, I mean, all the basics, the parties' names and ages, when did they get married? When was this divorce filed? What's the procedural aspect of the case? Is there a trial next week or no trial ever? The names and ages of the kids, of course, and all that background. That's the basics. But a good mediation memorandum is also going to tell me a lot about where your client is in the case. What is the most important thing to him or her? What should we really try and concentrate on? Mediation memorandums, at least in Arizona, are confidential. So you can tell me an awful lot and it's not going to get to the other side. So you can tell me flat out, hey, it's most important to my client to keep the house. So we'll do just about anything with the other assets so that she can keep the house. If you tell me that, I'm the only one that's going to know it. You're not giving up part of your case. So the least helpful memorandums are the ones that just say, here's a list of all the properties. Here's a list of all the debts. And then it's kind of thrown at me and it's like, okay, what's important? What's not? So being honest with me and telling me where your client's at and wanting to settle is probably the most important thing in the memo.
And then, and you did say about having a list of all the assets and debts. Clearly that's a good idea to have in the memo.
We need that. Oh, don't get me wrong. We need that. But when I know nothing else about the case, that's just a list. I have no idea. Okay, they have retirement accounts. Have you already agreed they're divided? Is somebody fighting to keep all of them? Is there separate property in some? Tell me something about these assets.
So. And the same with kids. Do you have a 2-year-old, or do you have two, a 17-year-old and an 18-year-old? There's a big difference between parenting plans and things like that with kids.
Exactly. I've received mediation memos, and they go on for 5 pages about here's what's going on with all the kids, and so has special needs, and they attend school here, and they go on, and I'm really into this. I'm really interested in it. And then I get to like page 6, and it says, and the parties have already agreed they're going to have joint legal decision making and equal parenting. And I'm like, okay, they've agreed. Why did you just give me 5 pages with background when they've agreed? So that's the kind of thing.
So then also narrow it into what they want you to help them figure out.
Exactly. I have to guess sometimes about what they have agreed on and what they're actually disputing. And sometimes that's hard. Also, some mediation memorandums do not give me copies of actual settlement offers that have already been exchanged. So I go into the mediation and then I find out, oh, there's 3 or 5 settlement offers, letters have gone back and forth, and they didn't even give them to me. It's like, well, I really need to know where you're at if you've already discussed settlement.
So that's another great point. What documents would you like to see besides the memorandum? What documents would you like attached to that memorandum?
Right. The least helpful is I'm sending you a Dropbox link, and this is all of our disclosure ever exchanged in this case. And then there's 1,000 pages in Dropbox. That's not helpful. The most important is, again, focus on what issues we really need to cover in mediation. If it's spousal maintenance, send me, in addition to any offers, send me what the payor makes. Send me his last W-2 or last tax return. Tell me what, if anything, the recipient of the maintenance can earn or is earning. Send me the list of expenses. In Arizona, we call it an affidavit of financial information, but tell me what she needs or he needs in maintenance. So those kind of documents, but sending me 5 years of tax returns, and each return's 80 pages, that's not very helpful. Just tell me what people earn and what they're asking.
So whatever's at issue. So if there's a house that's been appraised, you'd like to see that appraisal?
I would like to see that appraisal. And these days, everything's digital. So it's fine if the house appraisal is 40 pages long. Just shoot it over to me. I'll look at the relevant pages, and I'll see if there's competing appraisals and how we might be able to resolve that house issue. Okay, that's an important document.
This is off topic a little bit. It's on topic for that, but not on. It's kind of away from straying from the mediation. Zillow.
Oh yeah,
values.
I love getting off topic, and nothing's more off topic than mediation. Believe me. Zillow. I hesitate to bring this up, but I actually get into a lot of mediations where nobody has appraised the house, and the house is very much at issue. Maybe they don't want to sell it for some reason, but they're talking about who's going to get it. And it's like, well, what's it worth? So what can you do other than get on Zillow and get on Redfin? Redfin's another one, and just see what it says. And then I kind of like tiptoe back into the mediation room and I go, well, this is what Zillow says. And I'm always embarrassed because immediately I'll get, oh, Zillow doesn't know what they're talking about. But it's something. It's at least a number.
and I, more than they gave you, right?
Right.
I've heard that Zillow and Redfin are now more are more accurate than they used to be because they have so much information.
I have not found a lot of cases where they're wildly inaccurate.
Right. So, I think that's a better way to put it.
Right. So again, if you have a full appraisal done by a certified appraiser, I'm not going to wave Zillow in your face and to contradict it. That Zillow is a fallback. It happens to be free and easily available. And how can we not look at it when there's nothing else? So
yeah, that's true.
That's my feeling.
Yeah, mine too. Not that I don't do mediations. Annette and I were talking about this earlier. I'm not a mediator. I don't have it in me. I'm more of an advocate. I
You
think
have it in you. I've mediated cases where you were the mediator, I think. So
yeah, I just prefer to advocate. It just takes a lot of patience. Okay, so I got another question about what if you have a client that's not the easiest client. You want to tell the mediator something off the record or sort of not in front of the client.
Oh, and the mediator wants to know these things, believe me. So a couple of different ways. I am okay if before the mediation starts, if the attorney calls me and usually talks to my assistant and says, I really need to talk to Annette in private before this. Let her know a few things. First of all, my assistant or I will ask, well, is this something, should we do a joint call before the mediation? And I'll talk about joint calls in a moment. But let's assume that the attorney says, no, this is totally private. Well, during the mediations, I'm going to be doing an awful lot of caucusing, which means meeting with one attorney and one client separately. So I don't have any problem doing a brief caucus with one attorney ahead of the mediation. If that attorney needs to tell me, it often has to do with maybe a psychological issue of the client. My client is so nervous. He's going to cry the whole time. He gets very violent. I had that. His anger management is not good. So then we make provisions for getting him in and out of the place, or maybe we do it virtually. But I have no problem talking to an attorney on the phone ahead of time about that. Sometimes it's psychological issues. Sometimes it's just a real need of the client. She's going to need to leave at very early to pick up her kids from school, and she doesn't really want the other party to know that's what's going on. Okay, we'll deal with that. There's also the joint free conference telephone calls with attorneys, and those are very helpful. I do those a lot, where both attorneys just get on the phone with me before the mediation day, and they're very frank. They're like, hey, this is going to happen. That's going to happen. My client's not happy about this. It's usually not confidential things, but it gives me good background about why each attorney will be doing what he's doing with his client the next day.
Yeah, that's something I always appreciated, was going into a meeting with you, with the attorney, whether it's ahead of time or during the mediation, where we're like, all right, what is driving this? What is really driving this mediation?
Exactly. And you often don't find that while you're in the room with the clients, but you talk to the attorneys and they say, this is what's driving it. The third person, that someone's having an affair, the mother-in-law that's getting involved, whatever it is.
So, yeah, and I want to get back to that too, because there's always moms involved, right? Or there's always the parents, especially if you have young people, especially if the parents are paying.
Oh, yes. Yes.
They are often driving it.
Yes.
Do you usually let those parents in the mediation with you, or what's that look like?
Okay. That's always a big issue. Does any third party get to come to the mediation with the actual clients? And you mentioned parents, for example. If the parent or the third party is crucial to the settlement, if that parent or third party is going to have to write a check or sign a deed in order to make settlement work, then somehow they need to be involved. They're an absolutely essential party. We can't settle the case without them. So that's one thing to deal with. I usually tell people, hey, I don't have any real problem with third parties in the mediation to an extent. If they become a problem as opposed to an assistant, I may ask them to leave. But I do require that they tell me ahead of time, and they tell the other party ahead of time if a third party is going to be there, because I want to know if the other party objects. If there's an objection, then we have to have a procedural phone call. We have to work it out. If it's a very helpful third party, like an expert witness, a business evaluator, the home appraiser, whatever, they're usually available by phone or video. They usually don't have to come in and sit there the whole day. And that's always fine. We get those people on the phone all the time during mediations. The parents, the problem is you never know ahead of time, is this person going to be a huge help to settlement or a huge hindrance? And sometimes the attorney can tell me ahead of time which they will be. And that helps. I did have one case, I'll tell you, total parenting time case, post decree, and both parties brought their significant others, new spouse with them. And that's fine. It was fine. Everybody knew about it ahead of time, but I never know. Well, the attorney in room A tells me, oh, wife's new husband is horrible. He's going to object to everything. Wife's new husband, in fact, facilitated everything, couldn't have been nicer. And we found out that it was husband's new wife who was causing all the problems. And the attorney, husband's own attorney, was amazed. She did not know that was going on until the mediation. So we figured out what was going on. We addressed her concerns. We got it done.
Oh, but interesting. So when I did do the mediations, usually for the judge pro tem, I didn't let the significant others come. I suppose if they were married, I might have been more.
They were married.
But if there was, I had an objection, I had somebody ready to forcefully come in, and I said, let your client know that if that person comes, I will have them trespassed off my property. And that was the way I handled that one. And then I think I looked it up later and found out that really you can, if there's an objection, then
right. No, these parties had agreed. And as I said, it was post decree. So these were actual spouses. Mm-hmm. And until we got into the mediation, the attorneys each thought the other party was the problem. And so by having them there, we were able to determine who did have the concerns. And like I said, I shouldn't say problem. The one new spouse had particular concerns that were not being addressed. And we were able to address them and got it done.
And resolved. Well, that's great.
Yeah. So that worked fine. So that was a large mediation.
So, oftentimes the courts will make people mediate, and sometimes it seems it's done even before there's evaluations on property, appraisals on property. So can it be done through that, before that, or what is your procedure on that?
Well, those are tough. And sometimes that's a reason to have a pre-mediation attorney phone call. If I've seen memorandums and it appears that a piece of real property is at issue, let's say, and nobody's had it appraised, and the memos, one memo says it's worth $300,000 and the other memo says it's worth $1 million, you can spot the problem ahead of time. So that might be when I get the attorneys on the phone, or at least address it really early in the mediation and say, look, how are we going to address this valuation issue? I mean, wife wants to keep the house at a value of $300,000 and husband tells me it's going to sell for $1 million. What are we supposed to do about this? And so sometimes mediations do turn into planning meetings, should I say, or discovery meetings. Well, we need more information. Why would he say it's worth $1 million? We think he has an appraisal he hasn't disclosed. So sometimes the mediations turn into disclosure and discovery meetings, and that's fine because it still moves the case forward. I have had a number of mediations, though, where there's no appraisal. It looks like that's a problem, and we're still able to resolve it. It turns out just because husband put in writing he thought it was worth $1 million, that there was nothing to back that up. And really, he was pretty happy with 400 or 500.
So what about like businesses, or, sometimes one party will have like a service business that's not really too valuable, and then maybe somebody else has another business that's not been evaluated. What do you do with that?
Yeah. And of course, it's always the spouse who's not involved in the business that thinks it's worth a lot of money. And the spouse who is involved in the business says, it's worth nothing. If I don't show up tomorrow, that business is dead. We can deal with those because usually the party who's not in the business maybe wants another asset. So we can work with it and say, okay, you keep the business. It does have going concern value. We go through what value it actually has. Do you really want an appraiser coming in? Do you really want somebody looking at each and every piece of furniture and computer equipment and file cabinet and putting a value on it? Or can we agree she keeps the house, you keep the business? Some mediations can be dealt with that way. If it's a larger business with a fairly large annual revenue, that's not going to work. But if it's a business that's just this is my employment, sometimes that can work.
And that's probably another really great reason to have a meeting with the attorneys beforehand to see what's, again, really driving it. Does wife want the business, or does she really just want the house and or to survive? I had one that where the spouse didn't really care about the business as much as she cared about having money for the rest of her life, a certain amount of money for the rest of her life.
Right.
And that's what she wanted. And so she got a house, and she got, a $15,000 a month allowance and no taxes. And it was good for her. And
right.
So it could just be that where
she didn't really want the business, but no. she wanted the results of the business. So, right. And that's fair. That's fair. But yeah, I was going to say something about the larger businesses. As I said earlier, sometimes these mediations turn into planning meetings. And sometimes if the business really does appear to have some significant value, we can use the mediation. Okay, who are we going to have look at this? Let's call XYZ appraiser. And you don't want a full-fledged appraisal, but you want a look-see. You want this person to look at the last 5 years of financials and give you a rough estimate. Do you both agree to use this person? We can use the mediation to reach agreements like that too.
And that's great too, because that gets things moving. And I think trying to fight that out in court takes a long time.
Anything that moves the case forward is a good mediation, in my opinion.
So one of the podcasts that I did was with Marlene, and she had talked about not being, the case moving sort of faster than somebody's mentally moving.
Oh, yes.
And so I know I have no doubt you run into that a lot.
Oh, yes.
And so what happens when, a mediation, once it's done, right? This could be the divorce that somebody's not ready for. Mm-hmm. This could have every single thing, and the divorce could happen, within a short time after, and somebody's not ready for it. So what do you do if somebody's just not like cognitively there, not
right,
ready to make those kinds of decisions? Or
right. And that comes up more than you would think. First of all, I would say part of this is an issue with the attorney properly planning with his own client in advance before the mediation. It should not be the case where the attorney and the client show up in mediation. They haven't really talked about this, and boom, the attorney and the mediator find out at the same time that this client does not understand, is not ready. So, but we'll talk about attorney preparation a little bit. But if this is happening in a mediation and one of the participants clearly isn't tracking, is not cognitively with us, attorneys need to be skilled in figuring out if their client's tracking or not. I mean, simple things like looking them right in the eye. Do you understand what we're saying? Can you repeat back to me what we just talked about on the house? We just talked about a proposal where you stay in the house for the next 24 months. And then in 24 months, it will be listed and sold. And this is what will happen. Can you repeat that back to me? Let's talk about what that means to you and see if the client can track it, can repeat it. If that's not happening, that mediation should not go forward that day. So I'm actually a big proponent. We schedule a lot of full day mediations. I mean, these things run 9 to 5 and well beyond 5. They're tough days, but sometimes they're required. I am a big proponent, though, of separating mediations into 2 half days or several sessions. And if a client's acting the way I just described, I think that's a termination of that day. And let's come back in a week. Let's come back in 2 weeks. You cannot allow the client to go ahead if they're not able to explain back to you what is going on, what the proposals are.
So that's an interesting thing, because I think I've only done mediations where they've maybe gone 2 or 3 days, only a couple of times. Maybe one was with you. What would cause you to decide like what case should go 2 or 3 days as opposed to 1 day?
Well, if either client has physical limitations, like, hey, we have to end this by 2 or 3 p.m. because the kids are out of school. Sure, we can try and settle it. by 2 p.m. But if it's not settled at 1:45 and this child's out of school, we're going to have to reschedule. So it could be physical requirements. I am not a fan of scheduling a 9 to 5 mediation. And then the old saying is, hey, if it's 9 to 5, nothing really happens till 3 p.m. So why don't we just show up at 3? but that's a joke. If it's 4:45 and we haven't settled, some people are like, we're just going to stay and we're going to power through. And I don't care if we're here till midnight. Well, that's not a good mediation for most people. Most people start to break down cognitively. Even if they're eating and staying hydrated, they're still not at their best physically. And I've heard way too many mediations over the years where a party comes back later and says, I didn't know what was going on. I hadn't eaten since 10 o'clock in the morning. My attorney was yelling at me. I was forced to sign this. You do not want that happening. So that's another example of we're going to break today. We're going to come back. A lot of times I look at a case and I just say, you don't want a full day mediation. We're going to start with a 9 to 1. We're going to get as far as we can, but here's the holes I see in the case in your mediation memos that you need to go work on then. Appraisal on the house. Wait for that subpoena from the bank that you both say you're waiting on. Finalize disclosure, whatever. Have your status conference with the judge. And then we're going to do another session after that. So there's a number of reasons. I'm a big fan of those and they work very well.
Yeah, that's a great idea. I don't think I've ever done any of those, but it is a great idea because people get tired.
Exactly.
Now, are they less tired now that they're staying home and they're on the, on the computer?
Zoom mediations have been wonderful. Think of the comfort level to a client. If that client, I mean, I have a great office. I have a great office and we're very comfortable and we give you snacks and food and we buy you lunch, but it's still a big hassle. This person under stress has to get in their car, find my office, park. They're in a strange place all day, strange bathrooms, everything. Think of the comfort level when you're sitting at home and your cat jumps in your lap once in a while and your dog barks every once in a while and you have your own kitchen and your own bathroom. That has helped facilitate so many mediations.
You ever have anyone drinking while they're with you?
Drinking alcohol?
Yeah.
Not that I know. I mean, I'm sitting here drinking right now and you can't tell what's in it, but not to my knowledge. Has that happened to you?
It's happened to somebody that I know where somebody had a beer and was drinking beers.
During mediation.
Openly drinking beer.
See, that's an example where I'd have to say, we're ending this because even if you sign an agreement now, you're going to claim later you weren't capable. So
yeah, I don't think it finished up. I don't think it finished well. When people start drinking and just blowing it off, it doesn't.
I've had some where one party was clearly in a recliner, like reclined back, not asleep, but just relaxed. And like I said, her dog came and went. She petted the dog, and it was nice to see someone that relaxed, trying to settle a very important case.
That's true, because they're not relaxed when they're sitting in an office, all day long.
If I have to go to a stranger's office and sit all day, I'm not relaxed. And I have to ask where the bathroom is, and I have to ask permission to go to the bathroom. Come on, that's not relaxing.
Yeah, as opposed to I'll be right back.
Right. Exactly.
I'm going to fix a sandwich, go to the bathroom,
Exactly. So yeah, I have seen much less stress on people for that.
So just backing up, if somebody's close to 5 o'clock and they're getting close, is it okay to stay, you think? But if they're not getting close and maybe one party's checked out, is that when you end it? Like, is it ever okay to stay till midnight?
Of course. No, well, I can't tell you the last time I've done that. It's if I've ever stayed that late, but I hear about it all the time. Of course, if you're getting close to 5 o'clock, I don't slam the door at 5 o'clock. I do tell people kind of early in the day, I say, you know what, I have a lot of patience now. We're getting along fine now. But when it starts to get dark outside, I get nasty. So I do tell people that. But no, if it's 5 o'clock and we're almost ready and there's just a couple more revisions on a written document and everybody seems good, of course, we're going to stay till 6 or 6:30 or whatever is necessary to do that. I have found when you wait for those things, you start to get into the little details at the end, and it's harder to settle those little details when it's that late in the day. So, but that's a whole nother
Yeah, we should do another one on that one.
Exactly, about what things to start with. And do you talk about personal property? And do you believe me, if you start talking about the furniture at 5 p.m., you got a problem. That's and then true. The last minute things other than furniture are also airline points and hotel points, the timeshare, which often no one wants it. It's often a fight about who has to take it. Those things coming up after 5 p.m. are just, they're everywhere. Happens all the time. But that's a whole nother discussion.
Yeah, that should be another one. And we should do that because there's that other one where you're like, let's talk about how deep you're getting into the Rule 69 agreement. Is this going to be the full going to court order, the full entire parenting plan? Because I've had that where somebody's preparing the entire parenting plan and now you're there for the next 3 or 4 hours trying to, the devil's in the details, right? So trying to get all that out.
What I do not expect, the goal at the end of a mediation, to me, is a memorandum of agreement, which is basically bullet points. Wife gets the house, husband gets this much money. The retirement accounts, here's a list of them. They're going to be divided by quadra. It's bullet points. When someone tries to get me or a client to read and sign a 15 or 20 page agreement at the end of a long mediation day, that to me is not a good mediation. No one should be expected to do that. A memorandum of understanding for mediation should be maybe 3 pages long. If you have a holiday schedule for the kids or something, attach that. But getting into all the boilerplate and all the lawyer stuff that has to be in the final documents, you can't ask people to sign off on that.
Do you have people come in then? Would that be just setting up another one if they're to get the details ironed out?
Well, yeah, but usually, I mean, if we get the big details done in mediation and have a bullet point memorandum of understanding, a common clause in that says, now the lawyers are going to go do the paperwork and we specify who's going to do it and who's going to review it. If the lawyers run into a problem, they don't agree on boilerplate language or language necessary to effectuate the divorce, we're going to submit that back to the mediator, Annette, and she'll make the decision. And that's agreeable to almost 100% of people because I've got the background of the whole day. If they're having just a fight about language, it can usually be resolved pretty easily. And close to 100% of the mediations I do agree to some language like that, but I can tell you 1 in 30, 40, 50 actually come back to me to solve a dispute. So those are rare.
That'd be interesting to talk about that at a later time too, kind of what details to put in there to make sure that it's safe, but you don't need to get too much
you can't force that on people when they're under stress. And I'm including the attorneys in that. I don't expect the attorneys to agree to a bunch of a boilerplate at the last minute.
Yeah, that's true.
I'm including the lawyers on the stress.
So how long do you think that an attorney should take? Like, how much time do you think an attorney should take to prepare for a mediation?
Oh, see,
and what does that look like, by the way?
See, if we go to the trouble of scheduling an 8-hour mediation, like I just described, you think a full day is warranted for this case. There's a lot to cover. I think between preparing the mediation memo and preparing your client, you should be spending at least a full day ahead of time. 4 hours on the memo, 4 hours with your client, or some division like that. A lot of preparation. You should not walk into an 8-hour meeting and be wasting your client's time and money just getting them ready now. So the clients, I've done a lot of writing, it's on my website, about tell your clients these things ahead of time, get them ready. Yes, you're going to be able to have bathroom breaks. Yes, you're going to be able to eat. You're going to spend lots of time alone in this caucus room I talked about, because I'm going to be over in the other room talking to them. Prepare your client for these big breaks when they don't see me. It's not unusual. It doesn't mean anything bad's happening. It gives you and your client plenty of time to talk, but prepare your client for that. Prepare your client for it being emotional and tell them they can leave and walk around outside for a while if they need to. Definitely tell your client that it's confidential and that they'll be able to tell me things privately that I won't repeat to the other party. Get them comfortable with that. But I just see if they know that ahead of time, it will help their comfort level.
Yeah, that's great advice too.
Most clients want to know, do I have to see the other party? Will I run into him in the hall? Is he going to be hanging outside my room? So we try to arrange, here's how you can go to the restrooms without seeing him. Here's what you can do. We're willing to accommodate all that. So let your client know that.
All right. Now, this is one thing that I used to do, and I don't know if it's a good thing or a bad thing, but you can tell me what your thoughts are. If it was a case that I was very prepared for, but I knew there was going to be a lot of time on the other side where there's going to have to be a lot of convincing on the other side.
Right.
Whether it's mental health, whether it's just somebody who wasn't ready for the divorce, whatever.
Right.
I would tell my client, look, if we're just sitting there doing nothing but BSing, I may respond to some emails and take off 0.2 here and 0.2 there. So
right.
to make it less expensive for them. Plus, I'm now not falling behind in work.
Exactly.
And that was something I prepared them for ahead of time.
Exactly. Prepare the client for that.
So not a crazy thing to do. I never really knew if anyone else was doing that, but I always felt like at least it cost my client less.
It's not crazy. It depends where your case is at, because if you're in mediation and your case is coming to trial shortly, you probably have a lot of trial preparation work to do on that client's case. So if that's the case, use your downtime to start prepping him or her for your examination. Okay, here's what we're going to talk about. You're going to tell me how you tried to get a job. And so start doing your trial prep if you're close to trial. Go through the other side's disclosure and make sure your client has seen, hey, he's trying to prove that part of his retirement is separate property and he's got statements to show. So go through those things. If you're not close to trial, then by all means tell your client, hey, I can charge you for half an hour less here. I'm going to go do this. You bring a book. I've often told clients to bring a book just to calm them down.
Right.
So I think that's good use.
Yeah, that's well, and what you said is great, is prepping them. You've got them right there with you oftentimes, unless you're, on Zoom.
Right.
But if you're sitting there next to them and you can go through documents and familiarize them with your evidence and your exhibits, I mean, what a great way to spend that time.
And if you're close to trial, you need to do that. So
that's a great idea. Right.
I had an interesting, I was the attorney in a mediation not long ago. So I wanted to mention this. I hope I'm not getting you off track.
No, that's okay.
We reached agreements, and it was relatively early in the day, actually. We reached agreements. Well, we'd been trying for a long time, believe me, but relatively early in the afternoon. So we had the mediation agreement, and my client was making statements like, I think we're there. I'm sure we're there. I just want to sleep on this. I just want 24 hours. I just want to go over this. Perfectly reasonable. No, perfectly reasonable. But what I told her was, happened to be a female. Men do this too. So this is not a gender thing. What I told her was, I said, 24 hours is fine. Okay, but I need to tell you, tomorrow, when you have questions about this, and when you've been thinking about it, I'm tied up. I'm going to be in court. So I'm not going to be able to be with you to answer those things. And I'm afraid you're going to fret about them for a while. So I told the mediator and I told my client, I said, we're going to go through this proposed settlement. I think it was 4 pages. Let's say it was 5 pages. I'm going to go through this with my client line by line, and we're going to discuss every single thing. And I said, this is in lieu of her taking the 24 hours. And I asked her, I said, if we do that and discuss every single thing again, are you going to be okay with it? And she said, yes. And it was probably close to 2 hours for her and I. I don't know what the other side did. I don't know what the mediator did. I don't care. And we went through it line by line, discussed everything about it. And at the end of that time, it still was only about 4:00, and she was fine with signing. But my big concern with this, I want to take 24 hours. It's a reasonable request, but in 24 hours, I wasn't going to be available to her for the whole 24 hours. So I was afraid.
Yeah. So what was the difference going to be, right? What she didn't know now, she's not going to know in 24 hours.
That was exactly my point. Exactly my point. if she had questions, let's find out what those questions are right now and go through them, because I couldn't be available to her for 24 hours.
Yeah, that's a great point.
It worked out great. The mediator kind of rolled his eyes, and I said, just get out of here and let us do it. And like I said, we spent probably 2 hours going over a 5-page document.
So I, you hear this, I mean, and some of the mediators who won't let you out of there without twisting your arm for a signature after 24 hours. And then there's other ones that say, if it's a good deal now, it'll be a good deal in 24 hours. So do you have an opinion on that? Like, I guess you said it's okay to wait the 24 hours, but you're not going to be available. But if someone is available, do you think it's less likely that they're going to settle than if they did it right then?
I used to say, yes, if we wait 24 hours, there is less of a chance this agreement will get signed, because you worry about them going out and talking to their best friend, their mother, their next door neighbor. And all these people say, oh, that's terrible, take him to court, because they have no skin in the game and they don't know what's going to happen in court either. So I used to say, yes, there's less of a chance of finalizing this. However, as an attorney, I've been through a lot of mediations where we did not settle that day and went away without a signed agreement, but we went away with a lot of new ideas and a lot of new proposals. And the case settles either the next week or the next month, or even 6 months later, basically based on what we talked about in mediation. So I am less likely to say now that that waiting makes the settlement go away.
Something you just said, which I think would make a whole nother great podcast, is how creative and new ideas that you come up with, and how creative you can be in mediations. And I think that's a subject of a whole nother podcast, because there are so many great creative things you can do in a mediation that you can't do, and that there's no way you're going to get in trial. So maybe we have to set up another one for that.
Absolutely. And some mediations, people come in and say, okay, we're here to get your ideas. You need to be saying to me as the mediator. And I'm like, oh, no pressure there. But what I'm always amazed at is the attorneys in the mediation come up with the creative stuff. So
sometimes they do, but sometimes the mediator coming in from outside is kind of like, well, why don't you do this? And you're thinking, well, that's a great, I'm unsure why I didn't think about that 6 months ago. Just looking at a fresh set of eyes.
No, we've seen a lot of other cases with similar issues. So, yeah. But when you get 2 or 3 good legal minds together, it's amazing the creative things you can come up with. So, and no, judges aren't allowed to be creative. They just have to. That's why judges are always begging us to settle, because they know if it's left up to the judge, they are really restricted in what they can do. Follow the law, make certain findings, and
they don't know, they certainly don't know the family as well as the family does, and what their holiday schedules look like, and what their kids need.
Of course not. Of course not. And they don't have the time to, you're going to get more time with the mediator than you are with the judge in almost all the cases we're talking about.
And more experience, honestly, in most cases.
That too.
I just read your short bio that should have been a book. And oftentimes, at least here, our judges are, at the minute they become a judge, they're on the family bench, and they've never dealt with any of that before. So you definitely get a lot of good experience. So let's say you go into a mediation, you as the mediator, what do you have a plan? Do you start out with the small things first, or do you jump right into the big, difficult things? What do you do?
Well, here's what I try to do. If somebody has strong feelings about it, somebody in the mediation, I take their feelings into account. But it's really hard for the mediator to know, do we start with the kid issues, or is that going to blow everything up and we're never going to get to the financial issues, or the opposite? So it's very hard to know. I try to look at the information I have from the mediation memos and decide, okay, do we have disputes here of facts in the case? Do we have disputes of opinions, which means appraisals, opinions of value, things like that? Or do we have disputes about what the law is? That comes up a lot in both parenting issues and financial issues. Which of these things are really the most in dispute? And if there are some things that are disputes of fact. I try to start with those because we can figure out the facts. Facts are facts. Opinions are not. So if I've seen in the memos that there's a dispute of fact about whether one parent did got all of his substance abuse testing done and it was all negative, let's figure that out. If I see that there's a dispute about whether all the bank statements have been provided or what someone earns, that's a fact. What someone earned last year is usually a fact. We can talk about self-employed people, but that's different. So I try to start with the disputes of fact and get through those and get somebody with a comfort level on facts. Then we can start talking about opinions. What's something worth? What could he make if he was working? What's the best interest of the children? That's an opinion. And then if there's disputes of law, I talk with the attorneys about how we can resolve those. Hey, let's look it up right now. Let's get an expert involved. Maybe you need to file a motion with the judge, something like that. So I try to sort out what are the disputes based on.
So you don't necessarily go for the easiest thing first. Like, let's get, and one agreement leads to a second agreement, leads to a third agreement, which leads to a fourth agreement.
Hey, if I have seen, yes, easy things first is certainly a way to go. If I've seen that their holiday schedule for the kids is really close, I'll try, and before the mediation starts, I'll try to have retyped the whole thing. I'll take it into each of them and say, look, this is my version of your holiday schedule. I've tweaked this, I've tweaked that, but tell me if you can agree to this. And that's very helpful sometimes. And yes, that's called getting the easy thing out of the way.
Yeah. Instead of eating the elephant or eating the frog or whatever that is.
First. Right. And so very rarely would I ever say starting with personal property would be the place to start because you're going to end up talking about the coffee table for 4 hours.
I bought that because my mom gave that to me and not to us.
That was my grandmother's, but we spent $8,000 refinishing it. So now what?
So we did talk earlier about, third parties in the mediation, and we talked about comfort levels and how important it is for people to be comfortable. Is there ever a reason to put two people in the same room? Is that where you're like, get all the liars together?
I've never heard it sound like that.
But no, is there ever a time to put people in the same room? What do you do?
Later in the day, when I hopefully have developed some level of trust with both parties, we have had joint sessions. And this, again, is most common with kid issues because I point out to them, you guys know your kids. I don't. I can keep walking back and forth and talking about whether child should be picked up after daycare or after school, but you guys know about this and I don't. So I will see if they feel comfortable being in the same room to finalize those kind of details about holidays, about child exchanges, about the child going to counseling and agreeing on a counselor. And it all depends on what everybody's comfortable with. Some people will, I have a couple really big conference tables. They're really long. And a couple times people have said, well, if my attorney and I sit at this end and he and his attorney sit at that end and I don't have to look at him, that's fine. And you sit in the middle in it. And it works because they really don't have to look at each other at this table. Most of the time, it's even more friendly than that. And they're willing to get together. Same thing on disclosure issues and discovery issues. If we're at the point where one party's claiming he's produced everything, all bank statements, and they're arguing about, well, yes, we have a Bank of America account, but now it's called Bank of Central Arizona. We have to get them in the same room to talk about these damn banks. So with those kind of things, I would encourage being in the same room for a while to work out details. Most people are okay with it.
And do you do that on Zoom also?
Yes, we do it in Zoom meetings too. Just open up another breakout room and get them in there together. And then I always promise them, you can go back to your private breakout room. This is just short.
Just a couple quick questions.
And screen share is so valuable on the Zoom mediations too. That's one reason to get them in the same room, because I actually show them the mediation memo while I'm preparing it. I say, okay, this is the language I put down for the house. Is this agreeable to everyone? So I do try to get them in the same Zoom room to review the language.
So do you typically type yours, or should the parties prepare a mediation memorandum and work on it? I've seen it both ways.
I have
where
too.
I've prepped it, but also now that you're saying that you prep it, I've got in there fully prepped and have something that I think, where you're just going to change a few things. What do you recommend?
Well, the best I can say is I know very few attorneys who want to be preparing their own Rule 69s in their own room. There's a handful, 3 or 4. Most attorneys prefer that I be doing it. They wanted a completely neutral document. The clients feel much better with it. I mean, how would you like to be, your wife, and you're sitting in there and somebody drops a piece of paper in front of you and said, okay, husband's attorney just drew this all up, sign it. That doesn't go over real well.
No, that's less fun, I'm sure, for them.
I would say 90% of the time, at least, I do the writing totally independently based on my notes. And usually when I'm trying to finalize the first draft, I have both attorneys come back to my office while I'm typing it, and I read them certain provisions. So we make some tweaks with just the attorneys, then we present it to the client. And then of course there's more and more tweaks before we get a final. So, but more than 90% of the time, I'm the one doing it. And then if there's mistakes in it, I can say, "Oh, it's me. It wasn't the other party trying to pull something over on you. I take total responsibility."
That's true, because all of a sudden it's because there was intent involved in the mistake.
Exactly. And with me, there really wasn't intent. I was just stupid.
Just did it. Well, Annette, thank you so much for being on here. Is there anything you'd like to add for what people should do to prepare?
The best I can tell you is to be comfortable with the process. And the more knowledge you have ahead of time, the more comfortable both attorney and client will be. And I put resources on my website about preparing for mediation that cover a lot of these points. And I try to add to them all the time, because no matter how many mediations I do, I learn something new every single time.
Oh, well, thank you very much. And I am going to add Annette's website at the bottom on the caption. And then you can contact Annette.
It's all free. It's all free on the site, and there's articles and everything about get comfortable with this process, whatever you need to do.
And you do have an amazing website. I have to give you kudos for that. There's times, I think all of the Arizona attorneys at one point or another go to Annette's site for something. It's a great source for resources of anything that you need. So thank you again, Annette. And I appreciate you being here. I'll talk to you soon.
Thanks, Lonnie. Great.